let me introduce both Dan and Stephen. Dan has learned about patenting through going through the difficult process himself and dealing with the bureaucracy and the paperwork, and has had the opportunity to work with a lot of brilliant minds, both through MIT, Carnegie Mellon, and has worked with individuals at NASA, and is the CEO of APA. And his colleague Stephen, co-founder, who has many degrees from MIT and also from NYU. And we're going to talk about everything related to a patent and how to best make use of one. So with that said, welcome.
Thank you.
Thank you. So my name is Dan Hussain. I'm the founder of APA. And just to give a little bit of background again, I think we got cut off for people who just joined. So I started out as an inventor, entrepreneur, and founder myself. I went through the very tiring and exhausting and cumbersome procedures of getting my patents. Eventually, I ended up getting around 25 patents. We licensed those patents successfully to Panasonic, Microsoft, Tyco, and people heard about our success and how we were able to overcome all that bureaucracy. And I started working with other founders from my university, MIT and Carnegie Mellon. Also did an internship at NASA, so NASA scientists were also our clients. And then that's how APA got started. So during the process, I figured out all the different rules and regulations. You can call them loopholes if you like, but they're perfectly legal, and allowing us to get patents now in less than 6 months from filing. Sometimes as short as 2 or 3 months is our track record, which is pretty much unheard of because big law firms have a certain strategy for when they work with large companies like IBM. So one common thing that people always ask us about is how to deal with litigation, licensing, and post-grant proceedings, which is if someone tries to invalidate your patent. So Stephen, who's got multiple degrees from MIT and a law degree, joined APA about a year ago, and he's going to be presenting on these topics. And we're also going to leave time for question and answer. I know that last time we had this presentation a few hours ago at a different group, there were many questions at the end, so we'll try to leave, I think, 15 minutes for questions. Okay, thank you. I'll turn it over to Stephen.
Great, thank you. So just to double check, this session ends at 5:45, right?
Correct.
Okay, all right, then we'll definitely make sure we leave time for a Q&A at the end. So thank you guys for the introduction. So as Dan said, there are many different aspects of patent law, and in some of our other talks, we focused on the application process and requirements for getting a patent. And that's at the heart of what Dan and I do at American Patent Agency. But ultimately, what you do with the patent is afterwards, right? Either you license it to other people to make money, or other people are infringing on your patent, and you can go after them and sue them, perhaps for patent infringement. So we'll take a look at those in this particular talk. Okay. All right. So as a standard disclaimer, this webinar is strictly educational and of a general nature and should not be considered legal advice for your particular situation. So as far as we know, this information is correct, but we are really just doing this for your own education, and we encourage you to seek professional advice from a patent attorney or patent agent if you want to learn more, especially for your own startup or idea. So attending this webinar does not constitute forming an attorney-client or agent-client relationship, and we are not liable for any consequence resulting from acting in reliance of the webinar or slides. So at this point, I promise that's the last time I'll read verbatim for the slides, and we will continue. All right. So the agenda is pretty straightforward. Just to make sure everyone's on the same page, I'll just go through what is, and of course, what is not a patent. And the three topics at hand are post-grant proceedings. So that's what happens in the patent office, what can happen in the patent office after you receive your patent. Litigation, that's what happens in the courts. And then finally, licensing. Those are business deals that you make with patents in order to monetize. So just to make sure everyone's on the same page, what is a patent, right? In our line of work, we find that sometimes there's a lot of misconceptions that some people may have about this. So a patent is a property right that enables the holder to exclude other people, and specifically 4 things: making, using, selling, or importing into that jurisdiction the claimed invention. Now it's not a unlimited exclusion. There's actually a few limitations that we have here. One is that it's limited in time. We'll talk about that in a second. And then the other is also limited in jurisdiction. So there's no such thing as a worldwide patent. Some of you may have heard of PCT, or the Patent Cooperation Treaty, but that's really a process by which it makes it easier, streamlines the process for you to get patents around the world. But in the end, you still need to be issued a regional or national patent. And in the United States, patents are only issued at the federal level. It's one of the few areas of law, like the military, for example, that only exists at the federal level. There's no such thing as, for example, a Massachusetts patent or a New York patent. And this is in contrast to other areas, other things that you've seen. Like you've seen Delaware Corporation, New York Corporation. But when it comes to patents, they only exist at the federal level. And one of the technical terms or legalese that I will be using, one of the jargon that I'll be using in this talk is the term infringement, right? When you infringe on a patent, that means somebody is practicing your invention without your permission. So that's like trespassing on the patent, and that's when you can exclude them from doing that. So we'll see the term infringement come up again and again in this talk. One thing I do want to emphasize is, this is a common misconception that we see as well, is that patents are a negative right. That means you have the right to stop other people from doing something. But curiously, just because you have a valid patent on something, on an invention, it's possible that you don't have the right to practice your own invention. Some of the most common possibilities are, for example, suppose you invent a new drug, right? You may need FDA approval. So even though you have a patent on that drug because it's novel and non-obvious and you fulfilled all the other requirements for getting a patent, perhaps the FDA has not yet approved for you to sell it to the general public yet. Another possibility is what we call a blocking patent. This is when you have an improvement on a patent on someone else's invention, even though, so yours is novel and non-obvious, but practicing your invention still requires you to practice someone else's. So for example, suppose someone else invented a chair and got a patent on it, on the first chair. And you invented the first rocking chair, so you got a patent on a rocking chair. But in order to make a rocking chair, you have to make a chair, right? So you would have to get a license from the other person first. Now, why do we have patents? We can think of it as a deal that's struck between the public and the inventor. And I really want to emphasize this a little bit because this will get at the heart of why we allow patents to exist in the first place and the people's motivations for doing so. We can think of it as this. In return for the government granting the assignee a limited monopoly on their invention, right? Because like I said, it's limited term. They can stop other people from using or making or selling that invention. In return for that, the inventor has to disclose their invention to the public, right? They cannot keep it a trade secret. And this is supposed to spur innovation and promote the growth of public technical knowledge. So when does a patent term expire? When does a patent expire? This is very important, right? Because it tells you how much time you have to monetize your patent. And when you talk to some older engineers, some of them will tell you, oh, it's 17 years. But now, since 1995, we've now harmonized this around the world. A US patent will expire 20 years from the earliest effective US filing date. But its efficacy only starts when the patent actually issues. And as you know, it takes a little bit of time for the patent office to examine and ultimately grant your patent application. In some fast cases, like the ones that we do, it could take just a few months. Other times, it can take a few years. So it's 20 years plus, a few months or a few years. And these dates will become important to you as you evaluate how valuable your patent is. Because once your patent expires, you'll lose that exclusivity, and anyone can practice the invention without your permission. One thing I want to bring up before I talk about rights, and this is another misconception that we get a lot. If there's one thing that I would change in patent law in terms of naming things, it would be this one. So the word provisional comes up twice in US patent law, but in two completely unrelated contexts. And this is where a lot of inventors get confused. We hear a lot about, we do a lot of provisional patent applications. In fact, our firm files many provisional patent applications for our clients. And that's completely unrelated to the idea of provisional patent rights. So due to the time limitations of this talk and the scope of the topics, I will not be talking about provisional patent applications, but I do want to talk a little bit about provisional patent rights because that affects licensing and litigation. So as I discussed before, in general, patent owners may only collect damages for infringement after the patent issues, right? That's the whole point of a patent being issued, right? So suppose I applied for a patent today, right, in May of 2020, and it gets granted December of 2020. It's only from that date onwards, the issue date in December, that I can start enforcing my patent. If somebody else had been practicing my invention before the patent issues, generally speaking, I can't do anything about that. I can ask them to stop, but only after my patent has been granted. And it only covers activities that were performed after the patent has been issued as well. But there is a bit of a leeway in that, and that's what we call provisional patent rights. And what's interesting is that this allows patent owners to seek retroactive damages for patent infringement for activities occurring, and this is very key, after the publication of the patent application, but before issuance of the patent itself. I'll explain what that means. So when you apply for a patent application, it's secret, right? No one finds out about the patent application. But in most cases, with only certain exceptions, 18 months after you file for a US non-provisional patent, the application will automatically publish. So 18 months later, everyone will know that you have this application. And this is true regardless of what the status of the application is, right? So even if it's in the middle of examination and it has not yet been issued, and the examiner, you're still going back and forth to the examiner, the application itself will be published 18 months after you apply. So in between the period that the world now knows about your patent application and before the issuance of the patent itself, this is where you have something called provisional patent rights. But it's more limited in scope. There has to be certain requirements that have to be met compared to infringement after the patent issues. So it requires two things: that the third party, the infringing party, had actual notice of the published patent application, right? So usually this means that you have to prove as the patent owner that they knew about your published patent application. And in real life, this usually takes the form of you as the applicant, patent applicant, and ultimately the patent holder, learning that one of your competitors is practicing what you will soon have patented, right? And you actually send them a notice. You say, hey, just to let you know, we applied for this 18 months ago, and our patent application just published. Here it is. We believe that we will get our claims issued pretty soon, so you better stop, right? So that's the first requirement. The second is that the invention as claimed in both the published patent application and the issued patent is substantially identical. And of course, this is out of fairness, right? So during the patent examination process, the applicant will usually amend their claims, right? Either make it broader or narrower, or just change the scope a little bit, clarify terms. It's only fair to, quote unquote, punish that third party who had actual notice if the claims that you get are actually pretty similar to the ones that were published, right? You can't punish someone for something that they did not know about. And the note at the end of the slide is very important too, is that after patent issues, there is no notice requirement. So ignorance is not an excuse for infringing on someone's patent. That's how powerful patents are. If you have a patent on your invention, this is after it issues, and then someone else practices your invention, even if they did not know about the existence of the patent, they are still liable for patent infringement, right? Does that make sense to everybody? Good. All right, and licensing and litigation get complicated when you have two or more parties that jointly own a patent. One thing I do want to emphasize is that this is when you have multiple co-owners of a patent. This is different from co-inventorship, right? Co-inventorship is when you have more than one human being who are the inventors of the invention. Joint ownership is when you have two or more entities. It could be human beings, it could be companies or organizations that own a patent together. So suppose you get together with your best buddy from high school. You guys do not form a company or anything. You're just doing this in your garage. And instead of forming a startup, you decide to get a patent in your own names. So now you and your buddy co-own this patent, right? So what happens if a co-owner wants to license the patent to some other company X, but then the other co-owners do not, right? And another possibility where this comes up is, what if a co-owner wants to sue some other company Y for patent infringement, but the other co-owners do not? So think about it. Do you think it's is it just requires one person to agree, or is it unanimous, or is it by majority rule? I'm just curious what people think. Actually, let's try this. How about people type in what they think the answer is into the little chat? I just want to see what people think the answer is in this case. I guess if I don't see anything, I will start talking after a few seconds. It's not obvious, only one. Okay, so someone thinks for both licensing and infringement, and for suing for infringement, unanimous consent. Okay, good. Yeah, this is exactly, yeah, people are getting different answers. And the answer to this is each country has different rules. All right, and that's why this is so interesting. So how it works in the United States is, in the United States, each co-owner can individually license the patent to anyone else without the other co-owner's consent. But if they want to sue someone else for patent infringement, then all the co-owners must unanimously agree. If you think about it, it makes sense that those two answers go together, because suppose I have 5 co-owners on a patent, and then 4 want to sue this company for infringement, but there's one holdout who does not want to. That means that holdout basically gave that third party a free license, right? So it makes sense that if you require unanimous consent for patent infringement suit, then you also should allow it to be an individual to provide a license. Okay. All right. Now it gets a little bit. Let me see. Oops.
Could you just restate that, please?
Oh yeah. So in the United States, each co-owner can individually license the patent to anyone else without the other co-owner's consent. But for infringement, all the co-owners must unanimously agree in order to sue somebody for patent infringement. And
but
that's
you
only
have an operating agreement amongst the patent owners to not license it.
Say that again?
We could have an operating agreement among the co-founders not to license it.
That's correct. Yep. So you can actually contract around this however you want. But this is the default rule in the absence of a contractual agreement.
Thank you.
That's a really good point. Yep. And the way around this, and this is what we usually recommend that co-owners do, especially if the co-owners are individuals, is to create an IP holding company or startup company specifically to avoid one of these, this issue and some other related issues as well. And then in the bylaws for that company, then as you said, then you can write in, okay, what's going to be our rules for deciding whether or not to license or to sue someone for infringement. That's exactly right. So as I said in the notes below, the answers depend on the country, and I'll have a list at the next slide about how that works in other places. And it also gets complicated in the case of a human patent owner who gets divorced, because in some states, community property states, it's possible that suppose the wife got a patent during the marriage. It's possible that during divorce, the judge might actually grant half the patent rights to her ex-husband, right? Which means that if you want to sue for patent infringement, you would have to get your ex-spouse's permission, right? And obviously that could be pretty complicated. So the workarounds that I mentioned, as I said, assignment to a jointly owned IP holding company, and then you can write into company bylaws whatever rules you want. 2/3 owners agree. With, maybe people have different levels of shares. And some of that has to be above a certain amount, something like that. So as I said, that's the US rule, right, in the first sentence. Other countries sometimes have the opposite rule, right, where each co-owner may individually sue for infringement, but then they all must unanimously agree to license, right? So Here I have a list of some companies where that's the case. Germany and India have this additional provision where, but then there are venues to force the other co-owners to consent to licensing. And then there's a pretty limited scope in which that can actually occur. All right, whoops. Now in Japan, South Korea, and Taiwan, there's an even stronger situation where even selling or signing a share actually requires consent of other co-owners, right? So as you can tell, this can make things pretty complicated for people, but I want to make this clear. Hopefully this convinces you that it's smart to have a single entity that owns the patent. And then in France and mainland China, there's actually something else that's interesting too, is that even though licensing by one co-owner is permitted, the proceeds must be shared by other people, okay? And then Australia is unique in that both licensing and enforcing infringement require unanimous agreement among the co-owners. Okay, and I only mention this because this gets into licensing and suing for infringement, so it's nice to know how that works when it's complicated by multiple co-owners. Oops. Okay. Now, in patent law, there's generally 3 areas split by areas of law. So our firm, American Patent Agency, we exclusively practice prosecution. To some people, that's kind of a misnomer, even among attorneys in other areas of law. So prosecution doesn't mean, like in criminal law, when there's a prosecutor, prosecuting someone for a crime, representing the government. In this case, it just means this is the back and forth process with the US Patent Office to help our client get a patent. And as I mentioned before, that happens only at the federal level, right? There's no such thing as a state patent. Litigation is what happens afterwards, right? This happens in the court system. And because patent law is solely federal, we usually only concern ourselves with the federal court system, of which there are 3 levels. There's the district court, that's where cases usually start. And then there's a special court, the CAFC, or the Federal Circuit. That is the only circuit court, that's the only federal court outside of the Supreme Court, actually, that has nationwide jurisdiction and it actually has exclusive jurisdiction over patents. So it just tells you that Congress created this back in around 1982 or so, just so that there is uniformity around the nation in terms of patent law. So, and of course, we go up to SCOTUS, or Supreme Court of the United States, but that's relatively rare. Something like 97% or so of federal circuit cases just end there. The Supreme Court would decline to hear appeals from the federal circuit. So a lot of the case law that you hear, especially over the past 20 or 30 years, comes out of the federal circuit. And then finally, we have licensing, right? This is when you make deals with people, usually if you have a patent on an invention, but then someone else would benefit from it, you can have a win-win situation and strike a deal. One thing about licensing that's different from the other 2 is that licensing is governed by business law and contract law, which is usually only at the state level, right? So the laws concerning that might differ slightly from state to state. Of course, nowadays there's more harmonization between different states. There's still some pretty significant differences as well. So I would encourage you to contact your corporate attorney if you want to find out, what those are. And a really good patent strategy, of course, involves understanding all 3, right? So the focus of this talk will look at the latter 2 a little bit. All right. I have a few slides here that talk a little bit about the process and the different parties involved. I won't go through this very much, but really just to give you like a picture of where everybody is, right? So during prosecution, the applicant and the examiner is the human being in the patent office who is reading and examining your patent application. And this could take a long time. And this is something that our firm, because of our experience and our expertise, we have pared this down to several months in some cases, right? So you get your patent issued more quickly. And of course, in the end, you can either get a rejected application or an issued patent. You can appeal that within the patent office to a body called the Patent Trial and Appeal Board, or PTAB. And then they can either affirm the examiner's rejection or they can overrule. Now, if you don't like PTAB's decision, you can actually bring it up to the federal court. So what you're doing is you're suing PTAB in court. And of course, they can go either way as well. So what's interesting here is that what you're actually doing is you're asking the court, sorry, my mouth is a little bit dry. What you're asking the court to do is to order the patent office to issue you a patent. And in some cases, you may actually win. Okay. And theoretically, you can go up to the US Supreme Court as well, but that's rare. And this is what's interesting. I'll talk about this in greater detail later. Post-grant proceedings. So now this is what happens after the patent is issued. And you're not home free once you have a patent. Other people can still challenge the validity in post-grant proceedings. That's why I'm teaching the seminar. It's not something that a lot of people know about. And they can actually invalidate your patent. Right? It's like, hey, that's not fair, but unfortunately, that's just the way it is. It would be as if, suppose you applied to college, you got into your dream school, and then you're about to go, and some third party appeals to the admissions committee and says, hey, so-and-so should not have been admitted to your school. And the admissions committee looks into it, and they actually retract your admissions. But you know, that sounds unfair for that context, but this is how it works in patents. The idea is that, you know, the patent office is not perfect, right? The examiners only have a limited amount of time to study your patent application. And you can't just say, oh, the examiner who's not perfect, they're done, so now I'm home free. No, because for public policy reasons, we want to have really good patents that stay valid, and then the ones that should not have been issued in the first place, we want to have venues by which those can be eventually invalidated. See some things in the chat room, so let me just take a look at that real quick. Okay, all right, looks like Dan has that covered. Thank you. All right, good. And of course, you can always go up to the court system as well. Now, what happens in litigation with infringement? So another thing that you can do with issue patents, and this is why patents are powerful, is you can sue other people for infringement, right? And as I said, once you have an issued patent, it doesn't matter if other people knew about the patent or not. I mean, if you want to be nice about it, sure, you should probably first send them a letter and say, hey, just to let you know, I have a patent on this product that you're manufacturing. Could you please stop, right? Cease and desist. And then if they refuse to stop, then you can threaten to sue them in federal court, right? So that's what happens with these infringement lawsuits. And Dan can tell you stories about that because he has personal experience with the patents that he owns in dealing with that experience. So what happens is that, you know, the courts can decide, oh, is the person infringing or not? And then if they are infringing, then you can pay damages or get an injunction to stop. But one of the other things, and this is a risk that you take if you sue someone for patent infringement, is that they can counter sue to try to get your patent invalidated. They can say, hey, yes, I am practicing the invention that you know, is covered by your claims, but guess what? Your patent is invalid for, you know, ABC reasons, right? So prepare for someone to fight back if you throw the first punch, right? So how does this work exactly? It's a really complicated process, and obviously I can't describe the full process of how this works, but I do want to identify some of the issues that you should examine as you're thinking about whether or not your patents will be challenged or whether to challenge someone else's. So some venues where you can go, you can do it within the patent office, right? For example, post-grant proceedings. There's federal courts, right? And then outside of the legal system, there's also binding arbitration, right? That's governed by contract law. And of course, that can be litigated as well, technically, but you have someone who's not a judge and someone who's not in the patent office making that decision, and then by contract, both parties agree. There's a whole host of potential grounds for challenging patents. Ownership and inventorship disputes sometimes comes up. Some of you may have heard about, I'm sorry, hold on for a second. Some of you may have heard about the CRISPR-Cas9 patent dispute about gene editing, right? Some inventors affiliated with Berkeley and then others with the Broad Institute at MIT and Harvard have disputes about who invented that first, right? One of the most common ways is the next one, which is that the patent fails one or more requirements, right? Novelty, non-obviousness, and so on and so forth. The most common way that novelty would fail is if the person who's challenging the patent says, hey, guess what? I found this obscure paper that someone else published 2 years before you filed for your patent, and therefore it should not have been granted. So the patent examiner didn't have time and didn't find it. And if the patent office or the court agrees, then the patent will get invalidated. Right? I'll talk about inequitable conduct later. And then there's a whole bunch of possible outcomes that can occur as well, right? Is that the courts can actually reassign the inventorship or ownership. They can say, oh, wow, okay, it looks like the incorrect inventors were named on the patent application, so they will force that to change. Sometimes in the claims, either some or all of them can be validated, or even the claim scope can be narrowed. And I just want to let you know that not all combinations of these factors are available, right? There's certain venues that prevent where certain grounds are not you cannot pursue that, and not all potential outcomes are possible as well, right? Like for example, for inequitable conduct, what happens is all the claims will get invalidated, right? Not just the claim at issue. So that's something to keep in mind. Okay, I'm not expecting you guys to read this whole table or to even memorize the whole thing. But I just wanted to give you a sense for the issues that are involved when you're considering different post-grant proceedings. If you look at the links on the bottom, or if you just Google up, different post-grant proceedings, then you can find all of this information. But I just wanted to point you guys out to some issues here. And you might notice in parentheses it says AIA, that's the America Invents Act. So one of the most far-reaching changes to American patent law was made in 2011, and it came into effect in stages in 2012 and 2013. Some of you may have heard that the United States used to be a first to invent system, and then we switched to first to file, which is in line with the rest of the world. So along those lines, many other changes were made as well to the patent system and patent rules. So some of these reflect those changes as well. So again, I'm not going to read this whole table, but I'll just point you out to a few things. So when I say what P, that means what party. And looking back, maybe I shouldn't have done this, but P in my table stand for both party and patent. So I apologize for that. But in here it stands for which party, right? So which, sorry, my mistake. It is patent, yeah. So what patents are at issue here, right? So with these different proceedings like reissue, supplemental exam, and so on, these are, any patent can undergo these. But then with the post-grant review, only a patent that was filed after, well, the date is March 13th, 2013, March 16th, 2013. So, you have to know whether or not your patent qualifies or not. Who initiates? This is important too. Sometimes the owner can initiate a post-grant proceedings. And then for others, it has to be a third party only. And there's a certain time window as well. Again, that obviously when you're going through it, it's important, but that's not important right now. But what I do want you to focus on though is the grounds, because different proceedings have different grounds for whether or not the patent should be looked at again, right? And I have it here. So for example, if you look at ex parte re-exam and also inter partes review, IPR, the grounds for those are both 102, 103 based on patents and publications. So 102 is novelty. So is your invention new? For example, did someone else invent it before you do? And 103 is non-obviousness, right? But they restrict that from the entire 102, 103 types of prior art, which is they only look at patents and publications, right? They narrow it to some extent. Now here's three other columns that I wanted to point out. And this is really interesting. Identification of real party. And look at the ex parte re-exam. You can actually anonymously, right, submit these things. It's like, so you're not trying to knock down someone else's patent anonymously. Even during prosecution as well, there's something called third party submission. So Dan and I have done that before as well, which is very interesting. This is, like I said, 18 months after you file for a patent, it gets published, right? So now the whole world knows that you're going through this patent application process. And in some sense, you're kind of inviting the world to try to knock it down. So if one of your competitors learns about it, they can submit a third-party submission during prosecution and say, hey, examiner, just in case you didn't know, here's some potential prior art, right, for you to look at. Estoppel is a legal term for when a decision has been made, can it be relitigated, right? And I'm sure, you know, when a lot of us were growing up, you dealt with this with your parents. It's like, hey, we already finished that issue. Why are you bringing this stuff over and over again over the years, right? But in the legal system, it's actually certain things are now estopped. So once it's settled, it becomes closed from further re-examination or litigation. And you have to be very careful. Look at the parts that I bold-faced. It's actually different. Some places it says raised or could have been raised, right? It's like, you know, speak now or forever hold your peace, right? But then some other ones it says raised or could have reasonably be raised. So it's a slightly different standard. You have to be very careful with understanding which of these proceedings to pursue. And I'm hoping that this will encourage you to look at them more carefully when you're evaluating which venue to look at. And of course, they have different levels of cost, which I didn't put in here, a different amount of evidence that you have to demonstrate. It takes a different amount of time. The other is the threshold, right? S and Q, that's substantial new question of patentability, right? Is it a new question that came up that you know, did not come up before? So I'm not going to go through all of the post-grant proceedings, but I do want to point out a few. Like, for example, a re-exam. It's a quality check where the USPTO considers validity of issued patents. That's a typo, I should say issued patents claimed in light of certain classes, right? So I do want to bring this up, is inventors themselves may actually file for re-examination of their own patents. But then why would you do this? Because the only possible outcome is, there's only two outcomes. Either some claims are found to be invalid, right? Or you have to narrow them, or it stays the same. So it doesn't get better, right? Why would you pay all this money to re-examine your own patent? What do people think? I want to see if you will put that, put that into the chat room. What do you guys think? Okay, all right. So here's one possible reason. Oh, that looks like someone said something. To avoid other challenges. That's exactly right. So patent strengthening, right? So if the re-exam finds that it's valid in spite of this additional prior art, then a court is unlikely to hold otherwise. It actually makes your patent stronger. So let me give you an idea how this might help you as an entrepreneur. Is that if you're willing to spend, you know, a few $1,000s to do this, you can actually then tell your investors, hey, guess what? Not only is my patent valid, but then it was beaten up twice by the patent office, and it came out just as strong, right? And it could actually increase the value of your patent. It's like you're buying a house, and it's like, yep, I went through the whole inspection again with even more hardcore inspector, and it still went through, so you don't need to worry about it, right? The other one too, and this is the second half of this slide, is that if it turns out that a prior art is so close that the claims must be modified, then re-exam provides an opportunity for you to narrow your claim scope. Because if this came up later in litigation instead, brought up by somebody else, what would happen is then that your claim would get canceled, right? Would get invalidated. So at least here, you would at least get something, right? You can narrow your claim scope, and this is an opportunity for you to do so. Sorry, I'm just going to check the chat a little bit.
Steve, do you want to answer the question about what is narrowing versus broadening?
Oh, do you want to answer that? Give you a chance to answer. Go ahead.
Okay, sure. Sudhakar, narrowing is when you restrict the scope of the claim so that where something was an infringement, it no longer is an infringement, or where something was prior art, it's no longer prior art. So, for example, if your claim is for, I'm going to use a silly example, for a teacup, for a cup, the narrowing claim would say a teacup with a handlebar. That would be a narrowing narrowing amendment because you're adding a feature that is required for infringement. That's called narrowing. Broadening would be if your original claim said a teacup with a handle and you deleted the handle requirement, well, you made your claim broader because now it covers a teacup with or without a handle.
Good, thank you.
Okay, thank you.
Great. So in the interest of time, I will move ahead a little bit and talk about infringement a little bit, right? So this is when someone else practices your invention without authorization, right? We talked about that before. But there's actually different types of infringement that I want you to be aware of. The most simple type is direct. So this is when the infringer practices every element of the patent holder's patent claim. And there's no other parties involved. And like I said, there's no knowledge requirement. Ignorance is not an excuse, right? It's that someone else does not have to know about the patent to be liable for infringement. But then if they willfully ignore the patent despite knowing about it, that could actually increase damages later on. There's two types of indirect. One is called contributory, and one is called induced infringement. So indirect is if someone sells or offers to sell within the US or imports into the US a component of the patented invention. We'll talk about what that means in a second. And then the other is engaged in conduct of inducing and encouraging third parties. So this is like you're paying someone else to infringe, right? So that would be considered induced infringement. But this actually requires somebody else to do the indirect infringing, right? You can't have only an indirect infringer. There has to be someone else who's doing the direct infringing as well. But these have a heightened bar. These do have a knowledge requirement to be liable for this. So for indirect, contributory and induced infringement, the person, in order for that person to be liable, they must have known, right, or knowingly intended. And that's, of course, different from direct. I do want to point out the component part because you're probably thinking, oh, wow, what does it mean to sell a component of a patented invention? So it only counts as contributory infringement only if the only use of the component, material apparatus, is in the patented product, right? So then it has a substantial non-infringing use, then it falls outside of the statute. So if someone has a patent on a bicycle, for example, some novel bicycle, and then you supply them, the screws that they use. It's like, hey, are you contributory? Well, no, because you can probably use the same screws in many other applications as well, right? Only if it's specialized for that patented product, then you would be liable for a contributory infringement. I will skip this for now in the interest of time, but I do want to talk about inequitable conduct because this is something that some inventors may not know about. So as an inventor, as an applicant, you have what's called a duty of disclosure to the patent office. That means that during the prosecution process, when you apply, you have to tell the patent office any information that may be adverse to your position, right? So if you know that someone else invented something very close to what you invented before you did, you actually have to tell the patent office. And that sounds a little bit counterintuitive, but the idea is that you're supposed to be the expert in your own field. So we kind of force the applicant to police themselves. And if they fail to do that, then the results can be quite devastating. And this is when someone else accuses you of violating that duty, right? So a successful inequitable conduct defense can actually render all of a patent's claims unenforceable. And it's a pretty high bar because it has a few elements that you have to meet. Most notably, intent to deceive the USPTO, right? So that the person trying to get the patent had to have known about the prior art reference and knew that it was material and made a deliberate decision to withhold it. Usually you don't have a smoking gun. It's not like you have one inventor writing to his colleague, like, hey guys, I found this piece of prior art that may destroy our patent. Let's not tell our lawyers or the patent office about it. It's pretty rare that you find such an email. But sometimes, when people spend a lot of money on litigation, these things come up. So how about from your point of view, as you're going through the filing process, who is obligated to satisfy the duty of candor? So every named inventor, every agent attorney. So then if you hire, me or Dan to work with you, we're liable as well, right? If we happen to know, oh, we read this paper just yesterday where someone published something very similar to your invention, 6 months before you invent, that you're thinking about filing, then we have to disclose that. And it's valid. The obligation holds from the day you file to the day the patent issues, right? And as I said, if you violate that, it could invalidate your patent. Now, one thing I know we're running out of time. So one thing I do want to mention about licensing that would be a little bit non-intuitive is this. Who has the duty to enforce a license? Let's go to here, right? So if you grant a license to someone else, it could be exclusive or non-exclusive, right? So an exclusive license is when I grant a license to someone and I promise, hey, I am not going to license it to anybody else, just you, right? Just like an exclusive relationship or non-exclusive relationship. Another way that you can limit a license is by field of use. So for example, in this case, I have a new type of engine. I could say, okay, I will allow you to make my patented engine, but you can only use it in lawnmowers, right? And I'll keep, and then I'll for myself, I'll just use it for cars and other things. Or I can do it by geography. For example, maybe I only operate in Massachusetts, whereas someone else wants to commercialize my invention in California. I would say, hey, sure, that doesn't eat into my market share. It's a win-win, so why not, right? So the reason why I'm mentioning that is because this actually affects what happens if you have an exclusive license and then there's an infringing party. So let me ask you this. Suppose I own a patent, I grant you an exclusive license, you're paying me a lot of money for this patent license, right? Someone else is infringing, but I'm too lazy to sue that person. You're gonna be pissed off as the licensee, right? You're like, hey dude, I paid you so much money for this patent and now you're not even stopping other people from practicing it. Why am I doing? That's not fair. These other people aren't paying, right? So let's see how that works when you're in that type of situation. So who enforces? Who has the right or duty of enforcing the patent? Generally speaking, only the patent owner has standing to sue, right? In this case, I wrote about non-exclusive licensee. You have to rely on the licensor. But then what about an exclusive licensee? This is interesting. Exclusive licensee can participate only if the patent owner has granted it sufficient rights beyond the license itself to confer standing. I know it sounds like a lot of legalese, but here's the idea, is that the licensee has to hold what's called all substantial rights in the patent. So if you're thinking about granting a license to someone else or obtaining a license from someone who's patented, I think you definitely want to make sure that in the licensing agreement, you mention who has the right and obligation to sue third parties who infringe, right? And look at the last part of this slide. The term all substantial rights is actually pretty difficult, and courts, there's a lot of history behind how these are interpreted, and it's related to other areas of law too. But it turns out that territorial limitations pass this test, but field of use limitations do not. So to go back to the example where I'm only practicing my own invention in Massachusetts, but then I grant this other guy a license to practice in California, that basically gives them the right as the exclusive licensee in California to sue people who are infringing in California, right? Because that's considered all substantial rights, including the right to sue other people. But if it's only a field of use limitation, like I keep an engine for myself for cars, but I grant you the license to use it for lawnmowers, unfortunately, that does not. So you would still need the patent holder's cooperation to sue a third party. So like I said, just like with any other type of deal that you do with anyone else, I mean, you guys are the entrepreneurs here, do your due diligence, right, on both sides, either as the licensee or the licensor, right, especially on all of these issues that we talked about today. So I just want to thank Venture Cafe Cambridge for hosting this seminar, and of course my own firm for sponsoring, American Patent Agency. Some of my other colleagues from my past contributed to these slides. Just as a plug for ourselves, here is our next session. So we just go to Venture Cafe's calendar. You can see that. This is when we'll talk about some of the things that you guys ask, is when do I apply for a patent, right? And what does prior art mean? So that's what we will talk about in that session. And here on the right side is my and Dan's email addresses. So thank you very much for your time. And if we have a few more minutes, we can have a Q&A. So hopefully you guys found this helpful. Thank you.
Can I ask a question?
Sure.
So you guys talked about doing research. I've been on the website for the USPTO, and it is a monster. Do you have any suggestions about how to begin doing research in a particular product that you're looking into?
Yeah. So for example, we have we sometimes do something called a prior art search. Is that what you're referring to see what the landscape is like in your invention? Is that what you're asking?
Yeah, and is that something that I could do, or I would need to have an attorney do it, and or maybe I could start it and then have the attorney do it?
So if you look at Dan's answers, those are two resources that we tend to use. Obviously Google Patents, right? But one that is much more, I think, tuned to the information in patents is lens.org. Just look at the chat. We use that ourselves, and we have our contractors use that too. So to answer your question, we do highly recommend that the inventor do a little bit of searching on their own just to get an idea, because obviously if within just 1 hour of searching you discover that someone else invented exactly your thing, then you have to rethink what your invention should be, right? You can also hire a patent agent or patent attorney to begin that process for you. Either they do it themselves. For example, Dan and I sometimes will do that. But more often, we actually hire contractors or a dedicated prior art search firm to do that for you as well. And usually, we ask the client, for a budget. Sometimes they may say, "Oh, we only want 3 hours of searching." Sometimes they want something that's much more thorough, like 20 hours of searching by someone who's an expert in that field, for example. It just depends on how much of a risk you want to take that the patent examiner will find something, right? Because if you spend X amount on a prior art search and discover that, oh, I guess there's no way that we can get a patent on this, and that just saved you the application fees, right? Of preparing an application and waiting for a long time and then getting rejected. Dan, do you have anything to add to that question?
No, I think I got everything, but I do think it's critical for inventors to do their own preliminary searches. You guys are most familiar with the technology and your invention, and you can be a lot more knowledgeable about your technology and what's out there, the differences, etc.
Anything else?
Yeah, I have one question.
Sure.
So if, for example, there's an invention that may be useful for, I'll say like a hedge fund or something like that, right? They may very well be using it. It may be in existence, but because they rely on secrecy, no one would know about it. How does that come into play?
That's a really good question. So this goes into prior art about, so you're saying what happens if party A files for a patent application on something, but then party B had already invented that before, but then they've just been keeping it to themselves as a trade secret. Is that what you're asking?
Yes, I'm asking that. So let's say party B is the hedge fund. It wouldn't be in their interest to even acknowledge that they knew about it, except that they may then be violating a patent ex post facto, right?
Oh, that's a good point. Yep, that's right. That's correct. Yeah. So something is only considered prior art if it was known to the public before filing, right? So then if someone else already independently came up with the same invention before, but then they kept it themselves as a trade secret, that would not be considered prior art. So you're right.
If you received a patent for something and you believe that a fund was profiting from it, is there any way to compel them to disclose whether that is the case?
That's a really good question too. Yeah, you need to have a certain level of evidence to show that there's a good chance that that person is practicing your invention without your consent.
Okay, and it's just one sort of, just to wrap this thought up, if you did that and they said, yes, we did, but here we can prove we've been doing it since 1985, does that then invalidate your patent and get them off the hook?
Oh, I see what you mean. Okay. Dan, you want to answer that one?
Yeah, so prior art is only if it's something has been publicly disclosed. So public disclosures include US patent publications, US patents, scientific articles, conference presentations, public use, or public sales or private sales. But if something has not been sold and has been used internally, confidentially, it's not considered prior art. So I believe that is your question. If someone was secretly practicing the invention 20 years ago, no, that would not be prior art to your patent.
That's right.
Okay.
But if they sold the invention to at least one person, it actually would be prior art.
Okay.
Or even if it was a secret sale, it still counts.
Even if it was a secret sale, yeah.
Yeah. Okay. It's something interesting to think about. Thank you.
Yeah, in fact, we will talk about those issues at that next session on June 4th. The idea of what constitutes a secret sale versus not is actually very hairy. And there was a case just a few years ago called Hussain that teased out what exactly that means.
So if you mention a few things and it goes out to your investor deck, it goes out on your pitch deck to investors, is that considered public?
That's a really good question. So there's an expectation. When you make this clear to other people, it has to be, you have to make the expectation clear that it's meant to be private. So for example, if you invent something, you have a chicken and egg problem, right? It's like, how do I get a patent on this if I don't have money? But then how do I fundraise for money if I don't talk to investors about my idea?
Precisely.
Right? Exactly. We go through this all the time. So what you have to do is when you prepare your pitch deck, you have to have somewhere, very prominent in the slides and also verbally during the meeting as well. You tell your investors, hey, this is a confidential meeting. Only disclosing this to you for the purpose of you evaluating whether or not to fund us. It's not to leave this room. And if for example, if for some reason that information was leaked later on or used against you, that would be considered not public information. That's not a public disclosure, right?
Yeah, Dan, I'm reading your comments exactly. So having the provisional in place before you do any dissemination is
exactly, and we do provisional applications all the time.
Right.
Someone asked Erwin, is there protection left if a provisional patent material is published? I'm not sure I understand the question. A provisional patent is good for 1 year. Provisional patent application is good for 1 year, and it has to be followed up by a non-provisional within 1 year.
Sometimes he's so funny. He gets cranky, like when he's sleeping. He's like, "Don't fuck with me," but he'll come and like lay on you.
Just let you know you're not on mute.
Did someone say something?
Yeah.
It's okay.
That's okay.
That's all right. I just want to say thank you guys so much for joining today, and I hope you are back next time. And if you are interested in learning more about patents, obviously come back on June 4th for the next session. I also do have a survey link for everyone. If you'll take a quick moment, it's 10 seconds of your time.
This was a very good session. Thank you, guys.
Good. I'm glad you liked it. Yeah. Please feel free to reach out to us if you have further questions, guys.
Absolutely, will do. Is it possible to get the chat also distributed, because I can't seem to be able to copy the chat. I don't know how to get that.
I also can't copy the chat, and I'm the host. So, so there's that. There we go. Okay, that's the link Sean just sent through. If you could just quickly do the survey, it's 10 seconds. It was wonderful to have you guys from APA here. I definitely learned quite a bit myself. Some of it definitely went over my head, but again, I'm new to the field, so I appreciate you guys taking the time. And Dan, thank you so much for going through and answering questions for everybody through the chat as well. I thought that was a really interesting synergy between the two of you.
Yeah,
you guys work together so
how
well.
we do this. Yeah, it's the only way. Yeah, it's the divide and conquer, right?
Yeah.
Yeah.
Well executed, you guys. You're showing exactly why you guys are a good team and why people should side with you when needing assistance with everything.
Thank you very much.
Absolutely. So emails for additional questions, and also come back for the next session on June 4th.
Thank you.
Thank you very much, guys.
Okay, see you guys in the next session. Bye-bye.
Yep.
Thanks.
Take care, everyone.
Take care.
Stay safe.
Hey, Sean.
Bye.